Hello everybody, my name is Ross Pitcoff of the Pitcoff Law Group here in New York. We help business owners resolve complex disputes between partners, shareholders, and third parties, and also draft corporate transactional agreements. The focus of mediation is something that has evolved a lot over the years. I think 30 years ago, parties might have thought as mediation as something you really put to the side. Because if there's a dispute, number one, you either go to litigation in the public forum and you're filing actions in either state or federal court, or number two, if your contract calls for arbitration, then you are taking your matter and you are getting an arbitrator to oversee the dispute and make a binding decision. Mediation is really an evolutionary process where parties can volunteer to have a neutral third party, generally speaking a retired judge or a very experienced practitioner in a specific field, and the parties will bring the dispute to this mediator, and the mediator will work with each side to try and reach a resolution. Now, the nice thing about mediation is, and it's a double-edged sword, but the nice thing is that it's non-binding, meaning parties can say, before we get into the whole rigmarole of going into court, before we spend all these funds and resources, and before the parties essentially commit character assassinations against each other in a public filing, let's see if there's something that can be done. And so each party will prepare what one calls a mediation statement. Those statements will set forth the facts of the dispute. Each party will set forth the damages that they're seeking or what they would like for a resolution. And then you have a day with this mediator where the mediator will work with both sides, putting the parties often in separate rooms to see if a resolution can be reached. Now, if you're able to accomplish this task, the nice thing is number one, you haven't gone through a 1 to 3 year process in litigation or even arbitration and spent tens of thousands of dollars on your dispute. And number two, often mediations are able to end where the parties can still continue to work together. I mean, imagine going to court against somebody, an entity, a business, an individual, whatever it may be, and then saying, well, now you owe me $100,000, $1 million, $5, whatever it is, but now let's keep working together. It doesn't really happen very often, right? So the mediation process often can be a vehicle and mechanism to have very constructive alternative resolutions where the parties damages may exchange hands, cash may exchange hands, but also products or services may continue through a new lens. So mediation can be viewed as paving the path forward, not only to avoid extensive costs, but to potentially save a relationship.